Good morning, good afternoon, good evening. I'm Nicolas Veron on behalf of the Peterson Institute. Welcome to this new session of the financial statement series. Today we'll talk about auditing and audit oversight in the context of the China-US relationship. Actually, this session has been a long time in planning, when the dispute between the US and China on audit oversight was completely unresolved and apparently hitting an impasse. But in the meantime, we've had news in recent weeks that this dispute may be resolved after all. So this is very topical, lots of question marks with two outstanding speakers to try to disentangle the issues around this matter. Liza McAndrew Moobury, I hope I got the last name Swedish pronunciation right, was until recently director of the Office of International Affairs at the U.S. Public Company Accounting Oversight Board. I want to emphasize right away that she's not representing the PCAOB in this session. She left the PCAOB earlier this year. Liza studied in Santa Clara University. She graduated in 1994 in Spanish and accounting, which I think is a very promising combination. Worked at PwC in the US and in Finland until 2007, and then worked at the Securities and Exchange Commission, the SEC, for 6 years, between 2007 and 2013, where she was counsel to the director of the Office of International Affairs. And then in 2013, she joined the Public Company Accounting Oversight Board, which is a specialized body that was set up in the 2000s to oversee audit firms in the United States as director of the Office of International Affairs. Eric Forney studied at the University of Massachusetts Amherst at the Eisenberg School of Management in accounting, then Northeastern University School of Law, where he graduated in 2007. He worked for 14 years at the SEC, the Securities and Exchange Commission, in the Division of Enforcement. He was also Special Assistant U.S. Attorney in Boston on a part-time basis for 7 years, working on securities, financial, and cyber fraud. And he left the SEC this year, joined DLA Piper, the law firm, which I should mention is also among the generous supporters of the Peterson Institute, in June this year. Eric has also performed a lot of academic public service, if I can put it that way, over the years, as a joint faculty instructor at the Springfield Technical Community College, and then currently at both Northeastern University School of Law and University of Massachusetts at Amherst. With that, Liza, over to you.
Thank you, Nicola, and thank you so much for inviting me and Eric to join you on this panel. Let me go ahead and share my screen so that we can go ahead and go through a slide deck that, here we go, that I put together that has a lot of background information. It is available on the Peterson Institute's website. I won't go through all of it. We don't have enough time, but if anybody is interested in going back and reading some more, I do have the information there for you. All right. So I'm going to go ahead and jump to the punchline. Our question is, will this new deal that was announced last month resolve a decade-long dispute? The punchline is, it depends. It's a great step forward because there is no audit oversight if there's not an agreement in place. That's the case in China, and it's the case in many countries in the world. And now the PCAOB has an agreement. That's a fantastic step forward. I applaud that development both on the US side as well as the Chinese side. But at the end of the day, whether or not this resolves it depends on when the rubber hits the road, as we say. When they put it into practice, will the PCAOB actually get the type of information it needs from audit firms? They fortunately will be starting that test in this month, we hear. And there will be a report by the end of this year on a determination by the PCAOB. So we will, in short order, be able to know more about the answer to this question. So let me go ahead and quickly take you through the agenda. The first half of it is really going to be background. The second half of it will be my observations from what I've seen in the press releases from the SEC, PCAOB, and the CSRC. I have not been in the negotiations these past many months, so what I'm telling you is based on my observations as an informed outsider. All right, so background, who's on the US side? Well, on the US side, we're mostly talking about the PCAOB because they have a mandate to inspect audit firms every 3 years if they're doing work before on an issuer of securities, public companies, listed entities, if you will, in the US. The SEC, though, also has jurisdiction with respect to audit firms, not for inspections, but for investigations. Key point that I want to make here is while you hear a lot about the PCAOB's access problems, this is equally an SEC access challenge, and the Chinese willingness to cooperate with US authorities extends both to the PCAOB and the SEC. With the SEC, they also inspect the actual public companies listed on US exchanges. And so your Alibabas, your JD.coms, if somebody wants to look at whether or not they're making the right disclosures under US security laws, that's the SEC, not the PCAOB. On the Chinese side, my key point here is that while you'll hear about the CSRC, the MOF, all of my acronyms are at the back of my slide deck, so you can go ahead and read who I'm talking about there. The securities regulator and the finance ministry are the parties to the agreement because they, under law, have to be the ones to provide an overseas regulator with information. But there are a lot of other authorities behind the scenes. If you think of the DD listing and delisting, that was not the CSRC and MOF. There are a lot of other regulators behind the scenes that have a view on what Chinese companies do in their overseas listings, and that will apply to this PCAOB case as well. So in a nutshell, as I said, every 3 years, if a company is doing some work, the PCAOB needs to go and inspect them. The PCAOB, as of the end of last year, had 15 firms in China or Hong Kong that were due for inspection that they did not have access to. Access means not looking at company records, not looking at company personnel, and by company I mean the issuer of the security, but rather looking at the systems of quality control of the firm, looking at the firm's documentation, talking to firm personnel about what did the firm do to meet PCAOB and US standards. With respect to investigations, the one incremental thing on top of the documents is that the PCAOB needs to be able to take testimony, ask those audit engagement individuals, what did you do when you wrote this here? And that's the subject that I'm investigating. So a lot of access. I mean, it's kind of like a supervisory function at a bank and other institutions. But the key point here is all the PCAOB is looking for is documentation about the audit procedures, not the company's contracts, not the company's business plans, not the company's records. There's a lot of information on this next slide about how we got here. I just want to point out a couple of things to you. One of them is that this has been going on a good long time. So the PCAOB was told by Congress that non-US firms need to be overseen in the same manner and to the same extent as US firms. The PCAOB in 2004-2005 put into place rules for their oversight and began their inspections of non-US firms. By the end of 2009, they had already been in 33 non-US jurisdictions. They started their negotiations early, my first orange box with the Chinese authorities back in 2007, but it wasn't until 2013 that we saw some developments, first with an enforcement agreement, enforcement cooperation agreement, and then in 2016 with the agreement to do one pilot inspection, not ongoing inspections. It's only in 2022 that we finally have seen developments. The red boxes along the way are various times when the Chinese authorities have kind of raised their hands with new rules or regulations or laws that said no company, no auditor may give documents to an overseas authority unless it goes through the CSRC and the MOF. Big development here that we'll talk about next is in 2020, Congress stepped in, said, okay, enough is enough. We're going with the Holding Foreign Companies Accountable Act. We are going to give 3 years to see some progress or else there will be consequences. So how does the HFCAA work? Well, first, the act requires the PCAOB to determine if positions taken by foreign authorities prevent the PCAOB from inspecting or investigating completely non-US firms. So step one, the PCAOB makes that determination. It has a very transparent rule that's on its website about how it goes about that determination. and it posts the report that it issues to the SEC on its website, sends it to the firm. So a lot of transparency around this, which has been a huge step forward because of the HFCAA. Step 2, the SEC takes that list, that determination, determines which companies have issued a filing with the SEC that uses an audit firm in one of those jurisdictions, and then identifies those companies on the SEC's webpage. You might have seen a lot of press releases about which companies have been recently added to an SEC list of firms with potential future prohibitions on trading. Step 3, by rule, but this is not required by law, but by rule, the PCAOB decided for transparency, every single year it will reassess any prior determinations, at least annually, and it will go through the same process. It will publish its report, it will send it to the SEC, put it on its website, and the SEC then will keep current with its data on which issuers are using audit firms in jurisdictions where the PCAOB does not have access. So down on the bottom of the slide, here's the big question. Here's the consequence. Why does all of this matter? Well, if after 3 years, Congress is talking about accelerating that to 2, the SEC has identified the same company on its list, the SEC must prohibit the trading of that security. Now, that's not delisting. The law doesn't talk about delisting, but whether it's delisted or not, a question for the exchanges. If you're a holder of that security and you can't trade it, that's pretty consequential. So that step 4 is the big stick for the PCAOB and the CSRC to move this forward. The PCAOB in its transparent rule said that we will assess 3 factors in reaching our determination. And essentially it's, can we pick what we want to pick to investigate or inspect without limitations? Can we get access to the people and the documents we need in order to do that inspection? And can we do all of the other steps related to inspections and investigations, like issuing sanctions, issuing reports, referring matters to the SEC as required under our law? As I said, they published their first assessment. They determined 2 jurisdictions had authorities with positions that they took that prevented their access. That's mainland China and Hong Kong, the only 2 jurisdictions. Interestingly, it's because of the positions taken by the PRC authorities, not Hong Kong authorities. We can talk about that maybe in the Q&A. So some observations now. So that's all of our background. Really quickly, my observations. And I'll structure this as going through those 3 factors. What did the PCAOB say last year? And what am I seeing now in the August press releases that's interesting to me? Well, what did they say about the ability to pick what they wanted to do? Well, they said, 1, if there's no agreement, we can't pick what we want to do. It's moot because we can't get access. 2, the CSRC wants to control which issuer audits we select. You know, maybe the quality control wasn't the problem, but it's now when I need to test the quality control by picking some individual audits to inspect. The CSRC wants to influence that. Number 3, when we do ask them for things, whether it was in the pilot inspection or under the enforcement cooperation, they either don't give us things or they redact the document so we can't see the information we need. So here are my observations on that one. 1, we have an agreement now. So that big threshold has been passed. And the PCAOB made sure to say it has sole discretion to pick what it wants. And it says there are procedures in place for their inspectors and their investigators to look at complete information, everything that they need. So what the PCAOB is saying is the agreement, it signals that we should be able to pick what we want and see what we want. The SEC goes a little bit further on the redaction issue. And they say no redactions, they get everything without any redactions, and they tell us a little bit more about a special procedure for sensitive data to be seen in camera. So view only. The CSRC, this to me is probably one of the biggest developments. The CSRC acknowledges in what they call response to reporters, it's published on their website like a Q&A. They say audit work papers are just documentation of the audit work. They generally do not have state secrets. They do not have sensitive information. This has been a huge issue for years. And now we have the CSRC signaling that they're, in their view, these documents shouldn't have information that's problematic. I'm at time. I'll quickly, Nicola, if I could, make a couple of final points on access to the documents. A lot of this becomes repeat. They said we don't have an agreement. They withheld information. They didn't send us things. Here's the new one. No protocols for testimony. Well, here we have the PCAOB as well as the SEC saying the PCAOB now is going to be able to take testimony, and the CSRC acknowledges that they'll be there to assist. On the third factor, the only other interesting thing that's here is this is kind of a catch-all. It says anything else that we have to do. They said, PCAOB said, if we can't inspect and investigate, we can't do everything else. Well, the SEC comes along and says one of the everything else is to transfer information to the SEC as referrals. The SEC is saying that there will be no prohibitions against that. So looking ahead, as I said at the beginning, we now have an agreement. That's a huge step forward. The PCAOB has said mid-September they're going to start their inspections. The SEC has said that there have already been document requests and starting investigation requests. So we have an opportunity in the very near months to be able to see what happens. And then stay tuned. In December, the PCAOB will publish its reassessment of its determinations. And let's hope that there's some information on there that shares with it. Whether they determine that they have access or don't have access, let's hope there's information in there that tells us the progress that they've made. Nicola, back over to you.
Fantastic. Thank you so much. I have many questions, but first, Eric.
Well, thank you for having me, first of all. I'm really happy to be here. Liza, I thought that was really a fantastic presentation and overview. I'll be brief because I think we want to spend most of the time today doing some Q&A. So I'll just give some overview, sort of emphasizing some of the points Liza made. And I think it might be useful for me to come at it from two perspectives, because I've had the advantage of being at the SEC for about 15 years, as Nicholas said when he introduced me. And in that role, I did enforcement work, investigations, litigations. And for a bulk of that time, I did accounting fraud work in particular. And even within that window, I did work involving investigations into potential fraud involving Chinese companies that listed on US markets. I'm very familiar with some of the access challenges and some of the other challenges that come with investigating those sorts of matters. So, and then the other hat I'll talk about very briefly is now in private practice, representing public companies that have to balance regulatory requirements with their own stakeholder interests and ensuring that they're sort of meeting regulatory demands, but also balancing the fact that there are a variety of countries that many companies operate in that have sometimes inconsistent or incompatible demands that are critical to assess when providing informed advice. So just taking a step back, why does all this matter? Liza obviously references, but I go back to Sarbanes-Oxley, which was enacted in the wake of some really significant accounting frauds in the early 2000s, most notably probably the Enron scandal, which was a massive accounting fraud that sort of rocked the capital markets in the US. And Sarbanes-Oxley was enacted, at least in part, to address some of the issues that derived from the Enron scandal and related scandals around that time. It was WorldCom and other similarly situated large-scale accounting frauds. And Sarbanes-Oxley, often referred to as SOX, among other things, established the PCAOB, which is where Liza spent the bulk of her career. And as she alluded to, there was increased focus and responsibility on not just investigating public companies themselves, but also the accounting firms that audited those public companies and to inspect the work papers. So this matters, at least in part, because at least based on recent numbers that have been reported, there's several hundred companies in China that list in the US and trade in the US that in aggregate comprise over $1 trillion, that's with a T, dollars of capital markets. So, it's a huge amount of money, a huge amount of investment opportunity, but with that comes a huge amount of potential risk to investors. So let me first talk about my perspectives from my SEC days. Obviously, when investigating and trying to protect investors, which is the key mission of the SEC, to protect investors' market integrity, you want access not just to public company records to see what is happening behind the scenes and whether it's consistent with disclosures that are made in SEC filings. You also want access to auditor work papers for a variety of reasons, not the least of which is you want to see what the company is telling the audit firms to see if they're being candid with audit firms. And you want to see what sorts of questions the audit firms are asking to ensure that they are properly inspecting and auditing the public companies that have retained them. And that's all important in sort of trying to assess and establish the protections and disclosures that are required in order to protect the markets in the US. And that can be challenging, of course, when there are audit firms that are not providing work papers to the PCAOB when requested. And as Liza said, that's been going on for over a decade. This is not new. It hit ahead when, at least in my opinion, from an SEC perspective, it sort of hit ahead in around 2012 when the SEC sued a bunch of well-known accounting firms that operated in China for refusing to produce any work papers associated with their audits of Chinese companies that were listed in the US. And that led to an order that required those companies, those audit companies, to produce certain work papers, but, and I'm sure we'll get into some Q&A on this, there were some exceptions that appeared to enable the audit companies, firms, to withhold information or redact information that would relate to state secrets. And so that's, I think, the elephant in the room that is probably going to yield some questions today. And frankly, it's why Liza, I think, correctly started her presentation by saying it depends in terms of what we think the future holds here. So that's sort of briefly, I'm happy to get into more details on a variety of those things as the Q&A session begins, but that's sort of briefly my perspective from the SEC, right? They want access to everything. They believe they should have access to everything. In a lot of ways, when I was at the SEC, I would say they ought to have access to everything in order to adequately protect investors. But the reality is now having the opportunity to advise public companies in private practice, there are so many different regulatory regimes that you need to assess in order to properly provide informed advice. And you need to consider all sorts of collateral consequences and issues when providing advice to companies that operate in capital market space. And so one of the key balances here are obviously the laws that are in China and Hong Kong and how they affect both the public companies there and the audit firms that operate there, and how they are compatible or even incompatible with the US laws, including the fact that the PCAOB does have the authority to require audit work papers whenever it demands of audit firms. And so striking that balance is challenging. I will say now that I'm in these shoes in private practice, it's critically important for companies before assessing whether to turn over papers and to respond to demands to think about all of the different collateral consequences and laws that may apply and make an informed decision. You know, I'll leave it here before we get into Q&A. In the US, I know we likely have some participants who aren't in the United States, so I'll just make a quick note of sort of comparing and contrasting some of the issues you may face. In the US, there's this concept called the supremacy clause, where if a federal law is inconsistent with a state law, the federal law trumps. And so if you are a state actor deciding how to proceed and there's an inconsistent law, you will say to yourself, well, the federal law is the law I need to follow, is generally the rule. There is no supremacy clause that applies when there are laws that are inconsistent between one country and another. So balancing those laws and figuring out the tensions and which law to comply with and perhaps which law you can't comply with for a variety of reasons is something that will be challenging going forward as these new rules develop over time. So with that, I'm happy to participate in Q&A.
Thank you. We already a number of questions in the Q&A. There's a question which I guess is partly of clarification from Pierre Raffi. Would the SEC sanctions against Chinese companies affect already issued derivatives, options and futures, or stock derivatives trading? This is a bit specialized, but is also important for the scope of the agreement. Any of you want to answer this?
That would be on the SEC side. It's really a question of who an issuer is, an issuer of a security. And the securities are equity and debt securities that the SEC regulates and that would have an audit opinion, right? So the PCAOB inspects the audits of the auditors that do audits of US issuers, companies that issue securities, debt or equity, that require financial statements, audited financial statements to be filed with the SEC. A derivative doesn't have an audited financial statement that is filed with it.
Thank you. Broader question, which is, I guess, partly a political question. Why did this come now? Can you make any comment on the timing of the agreement? I found it very intriguing, especially with consideration of the Chinese political timetables, the preparation of the Party Congress next month, the Beidaihe meeting in early August. So are there any tea leaves that we can read into here? Maybe Liza first.
Sure. Well, so I think it really comes down to this 3-year timeline in the HFCAA. I'm sure that there are different politics and sign-offs that were happening in the background on the Chinese side, but really, once the PCAOB in December issued that first determination report and the SEC earlier this year started identifying issuers, the clock was ticking. And it takes a long time for the PCAOB to go out and do the work. The PCAOB signaled in its release, just having an agreement isn't enough. We have to get an agreement and test an agreement in a way that we know that, I think they called it sustainable, that they would have sustainable access. They would need to be convinced that this is not a one-time deal, but we actually believe we've seen enough evidence that the Chinese are going to continue to cooperate. So that's the position that they gave. Well, and it is pretty apparent that in order to get enough of that inspection and investigation work done takes time. And the next determination report that will start the year 2 out of 3, potentially 2 out of 2, identifications of issuers was about to happen. So it really needed to get moving, very quickly in order for progress to be made.
Yeah. Oh, sorry, Nicholas. I was just going to say, I agree with that. I think a couple things in response to that question. One is, I think this sort of is a natural result of the fact that the SEC has started to identify, as was its mandate under the Hold Foreign Companies Accountable Act, public companies that the PCAOB had not been able to properly inspect. And there's a long list of those companies on the SEC's website. And so as more and more companies are identified, you can see why they would be incentivized and their lobbyists would be lobbying the appropriate parties in China to help navigate the scenario where they can comply in some way with the PCAOB's requests, so they no longer have to be delisted and they can continue to trade on U.S. markets. So I think that's part of it. I think the other part of it is, it may seem like it's just happening now, but unfortunately in the law, at least in my experience, I'm not sure if Liza agrees, things happen more slowly than any one of us would prefer. And so the reality is, the SEC filed a case against various, as I alluded to, audit firms in, I think it was early or mid 2012, when there was concerns about their ability or their decision to not produce work papers based on audits they were conducting in China. It took about 3 years for an administrative law judge in the US to decide that, in fact, those audit firms had to produce records. That was in 2015. And then it took several additional years for Congress to decide to look into the issue further and to pass the, as Liza alluded to, the Holding Foreign Companies Accountable Act. It was relatively recent. And then it took additional time beyond that to then identify these companies, right? So it's sort of one of those things that kind of adds up over time.
Yeah, but my question is more about the Chinese decision-making timetable. And there's a political timeline which is very significant this year in China. And frankly, when you look at the agreement, I mean, we'll discuss some more aspects of it, but I shouldn't use that word, but it pretty much looks like unilateral decision by China to accept all the things that the PCAOB had asked for before. I mean, you will push back at my reading on this. So in a broader context of escalating confrontation between the US and China, tensions over Taiwan, blah, 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 it is actually intriguing for an external observer like many of us to see this stance of the Chinese authorities, even so, it can be rationalized and it's in their interest and it's good for the Chinese economy, but Chinese authorities have taken many decisions that are not obviously good for the Chinese economy in recent times, especially when it comes to the relationship with the US. So that's what I'm trying to get at, but again, many things we cannot really understand on what's happening in China.
Very quickly, Nicola, I agree with everything that you just said, right? It's rationally, it makes sense for Chinese companies' development to have access to US capital. Rationally, that is good for the Chinese economy, but at the end of the day, decisions will be made based on a complement of different authorities and what their motivations are at that time. And one press release that I saw, and I don't know if this is true, said that the delay that the announcement actually was made earlier, but the delay was because of the US-China tensions around visits to Taiwan. I don't know if that's true, but it just illustrates, it's an anecdote that is illustrative of, Nicola, your point that there's a much more complex environment that these developments are operating under.
We have questions about the difference of tone of the communications, respectively, of the PCAOB and SEC on one side, of the CSRC on the other side. And there's been a lot of chatter about whether they were saying the same thing. So one aspect of the agreement is that the work of looking at the work papers will take place in Hong Kong. Is that a problem? Is that something? The fact that the Chinese authorities will be present in the room, if I understand correctly, is that also a problem? I mean, can you get us a sense of these different modalities of the agreement? Liza.
Yeah, I'll take that. So there are a lot of words. Again, I've seen press reports that have made a big deal about some of the words on the Chinese side, like that they would be present. And one of our commenters here is pointing out an apparent inconsistency with Article 177 that says that no foreign authority can carry out investigations. Yet now we see it says we have an agreement on investigations. So just as general context, there are a lot of countries that say our companies, including our auditors, cannot give foreign authorities information without some control by a local authority. So all of the European Economic Area, right, the EU plus other countries, Switzerland, so, broadly in Europe, that's the way it works. And so if you read the details of the agreements with those regulators, which are actually all on the PCAOB's website, the China agreement was not posted, but with all of the European regulators, you can read those agreements and you find words about cooperating, discussing in advance, planning, being in the field together. And in fact, throughout Europe, it must be a joint inspection. So the Chinese authorities, of course, have focused on the aspects of the agreement that are important to them. We didn't concede that auditors can give work papers directly. We didn't say, go ahead and do what you want in our country without us being there. We are doing this together and in compliance with our law. The CSRC has to signal to the other powers that be in China, we are not disregarding state secret laws or any other laws in China. The PCAOB, on the other hand, is emphasizing in the SEC the things that are important to them. We got access that we wanted. We, no redactions, and that we can onward share to the SEC. It's just narrative management on both sides.
Yeah, the one thing I would I agree with all that. The one thing I would just add is that one of the statements that Liza pointed out in the slide deck is obviously quite interesting. The notion that generally audit work papers, at least according to the CSRC, would not contain state secrets. I'm not sure most, if not all, of the public companies that are operating in China actually agree with that statement. I don't know one way or the other, but it'd be interesting to see how that actually plays out, whether that's just a nicety at this point and whether in practice many of these companies will be scrutinizing, as they really should, because they're obligated to comply with Chinese state secrecy laws. What really is a state secret? And really, it can be quite broadly interpreted in China.
We've seen a number of listed state-owned enterprises, which are clearly sensitive in the Chinese context, the big oil companies. I don't remember, I think one telecom company, delisting on their own initiative from the US stock exchanges also last month in anticipation of the agreement. At that time, we didn't know the agreement was so imminent, but it looks like this was undertaken to alleviate maybe the burden of the state secret issue and make sure that the most sensitive companies would not be within the scope. How do you react to that? What is your interpretation of that sequence of PetroChina and others delisting from the US? Was it directly related to the negotiation of the deal or only optically so? What do you think?
I'm happy to go first on this one. I can't say that particular example was directly related to this arrangement, but I can say more generally, and I alluded to this sort of in my initial remarks, any company that's operating that has, in any country, never mind China or Hong Kong, that has its own state secrecy laws or related laws it is to comply with, that it deems inconsistent with the ability to turn over work papers, which might happen in many cases here, will then need to assess various options, including if we don't turn over work papers, can we redact them? And Liza talked a little bit about whether redactions will be allowed. The opinion that I alluded to from the administrative law judge in the United States on some of the accounting firms and their refusal to turn over any records implied that they could turn over some records, but while still withholding state secret information. Whether that will carry forward now remains to be seen. But ultimately you have to balance these tensions. And it may be that a company decides that it can't comply with US laws. It doesn't want to face delisting and some of the negative press that would be associated with that. And will just choose to voluntarily delist and trade in other markets, including the Hong Kong exchange or other exchanges that provide maybe not the same access to capital markets as US exchange does, but nonetheless significant access by its own.
Nicola, I'll reply to the question that you posed about the state-owned enterprises in a second, but one thing I do want to put out while we're talking about the state secrets. So imagine you are, so in the US, let's say Lockheed Martin, right? You have an audit, you're publicly listed. Let's say, I don't know who their auditor is, let's say it's Deloitte. Deloitte goes and does an audit. We know that there are probably some state secrets involved in there because Lockheed Martin is a military contractor to the US military, right? So I imagine that there are some auditors who can only go and look at some of Lockheed Martin's records with a security clearance. Those are state secrets as we in the US understand it. It's not really conceivable that that auditor then takes these highly protected, confidential documents and brings them back and puts them in their audit work papers that goes on a server at Deloitte that anybody in the, not anybody, but many people in the firm can go see whether or not they have a security clearance, right? So let's take that scenario and then look over at what we're talking about in audit work papers. The state-owned, even the state-owned enterprises, right, that are listed in the US, they're not related to the military. What we would think about as classified information is highly unlikely to ever have found its way into the audit work papers, okay? Like it's impossible that it would find its way into the audit work papers. There is a different standard for what is sensitive and what is a state secret in China than there is in most of the other parts of the world. So the SEC inspects in many countries, let's say in Europe, that have business secrecy laws, and of course they have state secrecy laws as well. They have protection of personal information. GDPR in Europe is a great example, a very, very strong protection of personal data. The PCAOB doesn't have problems there because there's a general understanding that the audit work papers don't have that information that the PCAOB then needs to take back with it. So when we talk about state secrets, I just want us to kind of temper or add some nuance to that. It's state secrets, but as interpreted by what the Chinese authorities have decided that day is sensitive to them. But let me come to your question, Nicola, about the state-owned enterprises. I think for a while, you know, let's start with, I don't think that the flow, the trading volume of any of those state-owned enterprises on the US side was terribly high in the first place. I think that Hong Kong was a more primary venue for them anyway. They got the reputational bump, they got the initial infusion of capital back when they did their IPOs. And I don't know what the US listings really was doing for them anymore when you weigh that against what I just said. Those companies are the ones that have transactions that the Chinese, state secret or not, will deem more sensitive. So if the Chinese do want to make some progress on this deal and keep access of capital, let's remember most of the companies by number that list in the US from China are not listed in Hong Kong or China. So this is a great flow of capital into small startups in China, right? The more development stage type companies. That Chinese authorities would lose that if the HFCAA impacts play themselves out, versus is there really such a need to keep those listings? So I do think, Nicola, it's very likely that that was a strategic decision on their side to be able to have the best of all worlds. And the SEC, the chair, has made a lot of comments about, you know, China, it's up to you to go ahead and delist some issuers that are too sensitive for you to keep on our markets.
So there's a very, I think, intriguing question by Elliot Posner on how the deal compares with some of the European cases. Some of us remember in the 2000s, there were difficult negotiations between the PCAOB and European counterparts. Actually, in some European countries, the counterpart didn't exist. It didn't even exist, and they had to create an audit oversight body in order to have an interlocutor to the PCAOB and be able to sign an MOU. So now that we have this deal, let's assume that implementation goes, you know, somewhat okay. In retrospect, will China have been really a unique case? Will it compare to what happened in Europe just a little bit later and stronger? How do you look at that, Liza?
So one of the things on my slide that I put a little statistic in there, in 2010, when the Dodd-Frank Act was passed in the US, we all thought that had to do with derivatives, largely, right? Trading issues. There was a little amendment to Sarbanes-Oxley that was put in there, which said the PCAOB now can actually share confidential information with foreign regulators. That was the provision in the law that made the problem with Europe. Europe and the Chinese, you'll see in the Chinese press releases, there's a lot of focus on reciprocity, right? They talk about how this is an agreement for both sides to cooperate with each other. Under European requirements, cooperation with a foreign audit regulator needs to be reciprocated. And when the PCAOB was prevented by law from sharing any information about what it was doing with the foreign regulator, it couldn't reciprocate. Dodd-Frank cured that. And so yes, in the early days, there were problems with Europe, but from that point forward, the SEC, the PCAOB executed agreement after agreement. You're right, Nicola, some of those audit regulators were brand new, and just starting to staff up. And they now have done inspections in every one of the countries in Europe where it's required. Again, I think our answer on your other question about, will China become like it was with Europe? Time will tell. I think the PCAOB and the European regulators have hit a stride. I think they work very well together. Time will tell if the enthusiasm for these joint inspections keeps up on the Chinese side. And importantly, not just inspections, the investigations are pretty resource intensive for the foreign regulator.
And you speak about that investigations, which also may involve the SEC, Eric. How do you look at the European experience here?
Well, I mean, I agree with what Liza said. I think time will tell, and I think in part it relates to not just the inspections, but really I was thinking as you were talking, Liza, about the investigations and whether, and this actually relates to another question that I see that came up, which is sort of what's sort of the next phase here, and what do we think may happen with a lot of these companies and will the PCAOB inspections be more robust in the first instance? I don't know about that. I'd probably best suited for Liza, but I guess my perspective is anytime you have more access to information, in my experience investigating cases for years at the SEC, odds increase that you find something that you want to investigate even further and to ask more questions about. And so I think one of the things in terms of the reciprocity and how cooperative China will be here is, it's one thing to make your audit work papers available. It's another thing then to have those work papers shared with the SEC, who will then potentially ask a host of questions for 3 to 5 years in any given potential accounting fraud investigation. That could make the cost of doing business and dealing with SEC regulations not worth it. And I think that's really what will be interesting to see play out. How many of these inspections, because we're talking really about the ability to inspect, but I think the next logical question in my mind is how many of these inspections are going to lead to investigations by the SEC of the company itself, not just even potentially for auditor malfeasance, but really usually targeted at the company itself for accounting fraud, lies to the auditors, which is a significant rule the SEC routinely enforces, and whether companies that are now facing that sort of renewed scrutiny want to deal with it.
So one of you, I think it was Eric, mentioned the SEC lawsuit in 2012. Was that in China or in the US? Can you tell us more about what happened in that context?
Sure, and I know Liza's quite familiar with it too, so I'll be brief. I'd love to get her perspective. But the SEC had requested work papers related to at least 4, and they were affiliates sort of related to technically different legal entities. There's a sort of marine structure of companies that have similar names, though not technically the same entity as the companies that operate in the US, like a PwC or a Deloitte & Touche. And the SEC had requested work papers of at least 4 companies that were auditing companies in China, and the companies refused to produce any of the work papers. And the SEC can make this request quite explicitly pursuant to a provision of SOX, Sarbanes-Oxley, which enables the SEC, similar to the PCAOB, to demand records both from domestic and foreign auditors. And as I understand it, the audit firms refused to produce any records, never mind redacted records, any records. And so SEC sued them, akin to essentially subpoena enforcement action, saying we demanded these records lawfully, you failed to produce them. And after years of litigation, a judge agreed that the audit firms had willfully violated the provisions of Sarbanes-Oxley that require the production of records. I believe each was fined, although the record will correct me if I'm wrong, $500,000, and was required to produce records that were requested. Now, the nuance there, which is really interesting to see how this will play out in light of some of the now more recent arrangements, is those audit firms were allowed to nonetheless redact information, including withholding. They could even produce what was called a withholding log, information that related to state secrets. So we'll see. It sounds like nowadays that sort of thing, at least the PCAOB would say, is not allowed. But you have this ALJ opinion in 2015. The balancing there will be interesting to see play out. But I'd love to get Liza's take too on that.
I'll respond to maybe less about the actual case and maybe a general observation about how it kind of fits, how it demonstrates how we've evolved now with the current situation. And that is PCAOB investigations, as SEC investigations, tend to be really behind the scenes, and the public doesn't really see what's going on until all of a sudden something goes into, in the SEC case, it goes to the courts, and you get opinions produced so that the public has a little bit of a view of what is this dispute that's been going on between in that case, the SEC law firms and or accounting firms and the Chinese authorities. The PCAOB has no ability to actually make public the fact that it's investigating anything until it's decided. And in fact, opportunities for appeal, when it comes to the some of the audit inspection things, opportunities to appeal to the SEC have to transpire before the public knows anything that's going on. What to me has been a sea change is that the HFCAA said this is no longer a spat that the PCAOB needs to try to negotiate with the Chinese authorities and the accounting firms to see whether people are willing to cooperate. The SEC settlement had an interesting feature that it basically it gave firms a time period. From this day, you have so long in order to produce work papers, and if you don't, then we're going to take action on you, right? It kind of acknowledged this long process that the Chinese side had to go through. Now everything has become much more transparent. The PCAOB, yes, has to go and try to do what it does, but it's not only on the PCAOB to take an action against a law firm, have it go through an appeal, have an accounting firm, have that accounting firm's issuer clients now not have an effective registration statement because their auditor is no longer registered with the PCAOB. All of those knock-on effects that the public wouldn't have been able to see are now very much in the light of day through these determination reports that will come out annually through the SEC's listing. So that's to me, that's been a fantastic development in the way that Congress approached this.
Congratulations to Congress for once. I have a question about Hong Kong. You mentioned, Liza, that the problems with inability of the PCAOB to inspect or investigate audit firms headquartered in either mainland China or Hong Kong was not because of Hong Kong authorities, was because of mainland Chinese authorities. So I'd like to better understand the role of the Hong Kong authorities here. Do they play any role? Is there actually an audit supervisor in Hong Kong that kind of is different from the CSRC? Can you walk us a little bit on the Hong Kong aspects of this? Because I know now there's a perception that Hong Kong is part of China full stop, but still on paper it's one country, two systems. So how does that work?
So there's a footnote in the determination report that describes some of this in the PCAOB's December determination last year. So there is an audit regulator in Hong Kong. They're called the Financial Reporting Council. They also want to inspect their own audit firms. And let me take a step back. The way audits of Chinese companies happen, if that Chinese company is using, let's say, a Hong Kong auditor, they can have a Hong Kong audit firm can sign the opinion on a mainland China company, and it basically does the work, but any audit work papers about the operations in mainland China have to stay in mainland China. So often they will have an affiliate, say in the mainland, that will house all of the records there, but really it was audit work that Hong Kong auditor is saying, I've done the audit, I take responsibility for it, I've done the procedures, and so I can sign the audit opinion. Well, whether it's the PCAOB or the Hong Kong regulator that wants to look at that piece of the work that is housed in mainland China, it's the PRC the mainland authorities that say whether or not there's access, and that they actually apply that same prohibition against the Hong Kong authorities that they do against the PCAOB. So what the PCAOB said in its opinion is, we acknowledge that there are authorities in Hong Kong, but the positions that we're taking, the positions that are being taken with respect to Hong Kong firms are positions of the PRC authorities, because the work papers are sitting in mainland China. So a bit confusing and a lot of moving parts back there, but in effect, the PCAOB didn't say anything that the FRC or there's a securities regulator there. There have been no actions that they have directly taken that were relevant to the report that the PCAOB produced.
So is it plausible to say that the FRC is a kind of bystander beneficiary of the agreement? That they will have better access thanks to the better access of the PCAOB?
So they have been negotiating themselves to get access, and there have been a number of press releases about different developments that they've talked about. Not a lot of transparency into what those developments entail, not a lot of transparency into how successful the Hong Kong authorities have been. And in particular, you can maybe the Chinese authorities would be willing to assist on kind of the smaller issues, but really, the issue comes up again when it's the larger, more sensitive companies. We don't know if the Hong Kong authorities have had success in those cases, the same way we do know that the PCAOB has not.
Enrique, on Hong Kong?
I'm really glad Liza took that question first, because she knows that area really well, and I don't have a lot more to add. I mean, other than to say that the SEC routinely does international investigations and routinely seeks to collect evidence from Hong Kong Securities Commission, and it will be interesting to see whether this will yield additional and better evidence to be collected and investigated by the SEC. We have a very robust, I think Liza spent time in their Office of International Affairs group that really facilitates our collection of documents from across the world, and more readily available access to these sorts of records will be hugely important to the SEC. And from my perspective now, private practice will be something that all public company clients will have to consider in terms of who has access to the records now.
So Greg Smith is asking some really broad questions about how that transforms the landscape for companies that are listed or want to list. Do you think, is this deal reinforcing the US as a place for dynamic Chinese companies to list? Conversely, will it lead to some flight from Hong Kong or for better attraction of Hong Kong for some listings? Lots of moving parts here. And of course, this deal is only one among many, many different factors that determine where companies may want to list. And anyway, we know that this year there haven't been many IPOs anywhere, because it's a bit of a big difficult year for IPOs. But any comments, maybe Liza first, on how that deal may contribute to evolutions in the geography of capital markets worldwide? Thank you.
Yeah. So couple of observations. Sarbanes-Oxley imposed a lot of regulatory burden or additional regulatory cost on companies. And there were a lot of foreign issuers that decided to delist, deregister from the US markets because of that. But subsequent to that, we saw the IPOs coming back, right? It wasn't a one-time turnaround and no, we don't want to be in the US markets. Specific to China, as we talked about before, will there be different calculations for some of the entities where the government is actually involved in some of it has discussions with them before they go and list? Think of Didi. I think the Didi example is one that, a lot of Chinese companies would think about their listing process and location very carefully after that. But at the end of the day, China in a number of different exchanges around the world, they're merit-based, and their listing requirements make it a lot harder for smaller entities to go ahead and list. Whereas the US system, it's disclosure-based. As long as you make the disclosure requirements that US securities law and regulations call for, you can list here. So I don't know that the vibrancy of other capital markets are where they would need to be, and that they have the depth of capital available that to compete with the U.S. But I think that that's not a question just in this past year. I mean, that's for decades that's been an ongoing debate about where fund capital raising will move.
So I guess I would add, two kind of maybe arguably divergent perspectives. One is sort of the utopian perspective, and one is the realistic perspective. When you think about what I would characterize as a utopian perspective, the SEC would, I think, take the position that regulation, and especially new arrangements like the one we're talking about today, might root out companies that should not be trading in the US because they're engaging in misconduct, and therefore enable the companies who are doing legitimate work and engaging in legitimate business to have better access to capital markets because investors trust them more. And there's still a number of people in the US and anywhere who are hiding their money under the proverbial pillow because they're afraid to invest their money. And this entire regulatory regime is designed to enable market integrity and to have people invest. So I think for the companies that are doing the right thing, it should actually enhance market access in the US. That's sort of the utopian perspective, right? The realistic perspective is complying with US laws can be cumbersome, it can be expensive, and it could identify malfeasance even when it's unintentional and nonetheless subject you to SEC enforcement actions or inaccurate books and records or things that don't even require any willful or intentional misconduct. And so it may be that companies just choose to avoid that scrutiny by operating elsewhere. So that's just a balance those companies will have to assess.
I can't resist. It's not our topic today, but bringing up the topic of so-called variable interest entities, because the SEC has actually accepted pretty, if you pardon my French, baroque arrangements for listing in the US, right? I mean, here we have companies that are ostensibly listed in the US, but they're actually what is listed is a completely different entity that doesn't own the business. So there's a perception, of course, in China that the US has allowed things to happen in their listing space that the Chinese authorities would not allow to happen because they're more risk averse, more conservative, but also perhaps more reluctant to allow things that can be really dangerous. How do you balance this? I mean, don't the Chinese authorities sometimes have a point that the US actually has allowed things to be traded on their exchanges that are pretty, slippery?
Well, I think I guess I can jump in first. I think the US would respond by saying that any company that complies with the US laws in terms of the registration provisions, and then subsequently the disclosure provisions, the rights of inspection that the PCAOB has, et cetera, should be able to trade in the US. It's a free market. It's a market with that's very robust, and it's been like that way for years. And so there shouldn't be any restrictions. I think the issue is, what about companies that trade here where they don't do the back half, the disclosure and enable inspections? That's the issue. But having any company that meets the definition of registration and fulfills its obligations, I think the regulators in the US would say, why not? And then it's up to investors to make informed decisions, right?
And any comments on variable interest entities and some of the more exotic stuff we've seen?
Sure. Well, one of the links I put on the end of my slide deck is a sample letter that the Division of Corporation Finance was sending to Chinese companies about the variable interest entities. So if you want to know, there's a lot more information out there. But I would observe this. While yes, Nicola, I think in the earlier 2000s there were a lot of boiler room problems that Western Canada had. Their exchanges had these problems, and the US certainly has had its share of not the most rigorous Chinese companies come through the door through these VIE entities. But I would also say Alibaba is listed as a VIE structure. So it actually is not a way for bad companies to try to evade everything and evade the US rules. It's as much that there are ownership requirements in China that even a company as large as JD.com and Alibaba need to use in order to be able to come into the US markets. But it's certainly a matter of focus for the SEC, and there's a lot more information on their website about that.
And certainly a matter that we may want to pursue in a future episode of Financial Statements. This one, unfortunately, is over because we're at the hour, but thanks so much to Liza McAndrew Newberry and Eric Forney for very illuminating comments. Next session will be on Thursday, the 29th of September, and we'll again speak about Ukraine, taking stock on the current situation, both economic and financial. In the meantime, again, many thanks to the two speakers, many thanks for the engagement of the audience, and have a great rest of your day. Thank you.